Hello, and welcome to the Marketplace of Ideas. My name is Anthony Vasiliadis. Today I had the pleasure of being joined by Professor Gans, who is a criminal law professor from the University of Melbourne, and he's advised the Victorian government on a number of issues. Today we talked about whether Australia should make our criminal justice system more uniform across the nation. We also discussed can we and should we make criminal laws about everything. Then we moved on to discussions of the difficulties in proving sexual assault cases, sexual harassment cases, and historic child sex abuse cases, including issues with evidence. And finally, we touched on domestic violence within Australia and any possible reforms we should be looking at making. I had a pleasure discussing these issues with Jeremy Gans, and I hope you enjoy them too. The main outlook I took away from this is the complexity of the criminal law system, issues of ambiguity, and the difficulties in creating a system that doesn't harm some individuals. Hope you enjoy. Today, I'd like to start our discussion off by talking about how the criminal justice system differs across the nation and pose you the question, should we make our criminal justice system more uniform broadly across the nation?
Yeah, well, this is a common argument that I hear, especially from my own criminal law students, is they point to differences in criminal law across Australia and they say, why don't all the states follow the same approach? And I'm familiar with that argument because in part I bristle a bit against it. It's true that some fundamentals of criminal law are ones we expect to be common, not just across Australia, but across the world. Things like the prosecution has the burden of proof, that you have to have a trial, that only certain sorts of punishments are on the table. We'd like to think those are common across the world, and they are generally common across Australia. But there are also a lot of things that we take for granted in Australia that aren't common elsewhere. So an example is in Australia, if a jury acquits you, it's the end. You've been acquitted, and except in very narrow situations, you're not going to get tried again. But I was really surprised to learn when I was doing my doctoral thesis that isn't true in Canada. In Canada, uh, if you get acquitted by a jury, the prosecution can appeal and say the jury got it wrong or were misdirected or something, and you can end up being tried again. In Australia, if that was proposed, everyone would be up in arms, and yet in Canada, everyone takes it for granted. So one of the lessons to me is that some of the things we regard as essential to criminal law in one place aren't regarded the same in other places. And no one thinks that Canada is some sort of dystopian hellhole that is much less safe or much less free than Australia. No one thinks there's a great difference between the two. So narrowing in a bit on Australia, those fundamentals are all the same across Australia, but there are a vast number of differences across all the states. Just to give an example, the definition of murder in New South Wales and Victoria is quite different. Victoria has a much broader definition of murder. More people are going to be murderers in Victoria than they are in New South Wales because New South Wales has a whole bunch of outs that aren't available in Victoria. So you might think, hey, why should it make a difference which side of the Murray you're on? But on the other hand, you've got a problem. Which is the correct approach? Is New South Wales' approach the correct approach? Is Victoria's the correct approach? And why would either of them be the correct approach, given that all the other states have their own definitions as well? That if you read about the United States, you hear about concepts of murder that are totally different to ones in Australia. And I don't see how you can have a rule that says one of those is the correct one. Or even that, we should assume that the rules should never change when you cross a border. Same is true of theft. The same is true, say, of sexual assault and lots of other crimes. They have different definitions across Australia. And my response to a claim that we should have uniformity is why? What's the rule that says that you should have the same rule applied to you no matter where you are in Australia? I think there are some areas of law where there should be uniformity across Australia. One is road rules. Although there are minor differences in road rules across Australia, the basic idea is that you don't want to have to change the rule book for your driving when you cross over a state boundary. It shouldn't matter that much. So that's an area where you can see why there should be uniformity. But I don't think that's true for whether you call someone a murderer or a manslaughterer or exactly what counts as theft or some other crime or nothing at all. So no, I don't think you should have the same rules across Australia necessarily. That being said, I'm a big fan of looking to see what others do when you're considering reforming your own laws or changes to your own laws.
So, correct me if I'm wrong, but from having a listen to what you've been saying here, is one of the reasons you think that it's okay in the status quo that we have different laws across the different jurisdictions is by recognizing that each different state comprises people with different sets of values around what the criminal law should be, and thus it's the benefit of the system to allow different states to do things in slightly different ways based on what their voters or their people think the criminal law should be, or is it something deeper than that?
I think it's actually something shallower than that. I don't think these
Okay.
differences, at least within Australia, are to do with differences in values. New South Wales people don't have a different value when it comes to human life, say, to Victorians. The reason that they have a narrow definition of murder is because New South Wales adopted an English rule about diminished responsibility, which is basically an extra out for people who don't fall within the insanity defence that lowers you from murder to manslaughter. They just tried it out from England. They thought it was an interesting rule. England had brought it in because they thought it was a useful rule to navigate the abolition of the death penalty. And then Victoria, for whatever reason, didn't adopt New South Wales's rule. I don't think there's anything to do with values in any of those calls. I think it's more the stuff of regular law reform and politics. People try things, others look and think, I'm going to wait and see how that goes. And just for example, when New South Wales adopted that rule from England about diminished responsibility, they had a couple of decades of argy-bargy in the courts and in the newspapers about whether that was a good rule or not. And I suspect what happened in Victoria is they looked at that and thought, the costs aren't outweighing the benefits there. Whatever flexibility that gave to the law of homicide in New South Wales was outweighed by constant fights about exactly who should get the benefit of that defence. So Victoria just decided not to go there. New South Wales, on the other hand, having adopted it, decided we've done all the work. We've tried to make this work. We've got used to it. Why should we drop it now just because Victoria didn't think it worked all that well? So I don't think any of that's to do with values. It's mostly to do with a bit of chance about how different jurisdictions adopt different laws.
So I can definitely understand like arguments to do with this that we might have a benefit in our different criminal law systems where different states can try things, see whether it works, have experiments. That's definitely an advantage to the system. But if we're saying that there isn't much difference between the states on values, couldn't you argue that the way to come to the correct system would be through something like a federal criminal code that's legislated? And that way, every Australian gets a voice in deciding how the criminal law should be applied broadly across Australia. And I think that would probably be fair. Or do you think that's a bad idea?
We do actually have a federal criminal code. It governs federal crimes, which are a significant part of Australian criminal law, but a part that doesn't necessarily get the kind of close attention laws like homicide do. So most of Australia's drug trafficking laws are federal laws, and there's a single federal code that applies to those. Lots of the laws you hear about in the news, things like bans on Nazi salutes or whatever, they appear in federal law, although there are also versions in state laws. There is this federal code, and in fact, when it was developed to be a model that the states could adopt and head towards that goal of uniformity. But for whatever reason, maybe tellingly, none of the states have taken up that model. The only ones who took up that model were the two territories, the ACT and the Northern Territory. All the states just had a look and decided, yeah, it's got some good elements, but it's got its problems too. And why should we, I guess there's a bit of a devil, I think, why should we switch to a new system which clearly has its pros and cons instead of our current system, which has its own pros and cons? In terms of this is a democratic control thing, I think that cuts both ways. It's hard to really pretend that voters all across Australia had any say in that federal code. No one paid any attention to it. It was driven by the Federal Public Service. On the other hand, state criminal laws, they are a little more susceptible to democratic input. So in Victoria, for instance, most of the recent elections in Victoria have had a law and order aspect to it, where people are more or less weighing in on criminal law issues. If you look at the federal elections, there's never any law and order aspect to them, or almost never, because no one pays much attention to the kind of issues that are governed by federal criminal law. So it's possible that states are a more democratic source of input than the federal system. The other thing you mentioned was experimentation. I think there is a virtue in each jurisdiction trying out things its own way. Ideally, one will try it out, the others will look at it and say, that's a great idea, we'll adopt it as well. That ideal is actually rarely followed through, but that's an ideal that's clearly got some potential benefit. I should also mention, there's been a lot of lot of focus on the question of uniformity in sexual assault law reform, rape law reform. New South Wales calls it sexual assault, Victoria calls it rape. Everyone has different names. It's another example of difference. But there were some interest groups who pushed very hard for uniformity across Australia on some issues in sexual assault law just recently. And the federal government did a law reform inquiry and a parliamentary commission and all sorts of things to try and encourage uniformity. The argument for uniformity was, when we teach kids about consent, we want to use the same rule book for all the kids, otherwise they'll get confused. That's not a very convincing argument, I don't think, because for a start, you can just teach Victorians one rule book and New South Wales kids another rule book. There's no confusion unless someone changes states during high school. Seems like a minor issue. And in any case, the kind of rules everyone's teaching don't turn on all the nuances of the statute book. They just turn on ethics and ideas about consent. The real agenda, I believe, of those people pushing for uniformity was they wanted to turn victories their movement had had in particular states, for example, Victoria, into Australia-wide victories without having to fight the same fight over and over again in every jurisdiction. And so I can see why they do that. That being said, I think it's good to fight the same fight over and over again. If you're on the right side of the fight, you'll win that fight every single time. There's no reason to shortcut it with a call to uniformity.
I guess that brings me on quite well onto the last question I had on this topic, which is that there are some notable differences between some jurisdictions. Some would kind of characterize it with certain jurisdictions being too left-wing, others being too right-wing. I know it's a bit more nuanced than that, but especially in contexts with things like gun laws, given what happened in Bondi recently, things about background checks, sharing of information, all of this has created a bubble of, do we need our criminal law, our safety checks to be more uniform? And do we need to be ensuring that certain jurisdictions aren't being too lenient or too strict? Do you see arguments coming there for at least certain areas of our criminal law, particularly things to do with terrorism or to do with youth offending, to start to become more uniform in the nation?
Yeah, I mean, I think guns is a good example of an area where you'd want to have the same rules throughout Australia because we don't have closed borders. You can just walk across the border. So if you could buy guns more readily in one state than another, then that would undermine the regulation of the other states. And that's exactly how the system works. When John Howard pushed everyone to bring in gun law reform in 1996, the federal parliament had no power over that issue. They could only regulate the importing of guns to Australia, but the heaps of guns already in Australia. It was the states and territories who brought in all those changes. And they did it by coming together and saying, we need to be uniform. We don't want one of us to undermine the other. John Howard managed to leverage, I think, fairly enough, the Martin Bryant-led massacre in Port Arthur to push them all to that position. And I guess we're going to see a similar process now with what's happened in Bondi. So that's a good example of where uniformity is a good thing. It isn't, though, because uh, there's no reason to particularly think that the problem that gun regulation is trying to deal with is worse in one state than another. Every state has had its problem with gun violence. Every state has potential risks from, say, terrorism. So this is, again, a good reason to have more or less the same laws everywhere, all right? I don't know if that's true of some of the other things you mentioned. So, for example, youth offending. Victoria at the moment is currently having something of a crisis about youth offending. Other jurisdictions have had crises about youth offending in the past. I think this is a common problem across Australia, but it doesn't mean it plays out the same way everywhere. There are different demographics in different bits of Australia. There are areas of Australia that have more young people or more disadvantaged young people than others. That could mean that you'd want to have different settings, as they tend to say these days, to deal with youth offending in some jurisdictions. The rules tend to, and I think this is the other thing to mention about this whole thing about uniformity, the rules change over time. It's not like there's a static law in Victoria. Victoria is always tweaking, so is New South Wales, so is Queensland. If they change over time, they're also going to change over place in response to different concerns. So I think that's how that's how it should be. With those sorts of issues, you need to have a bit of flexibility. The only caveat on all of that is where I started, which is to say there are some fundamentals that you expect to stay in place, not just from place to place, but over time. So, say a requirement of proof beyond reasonable doubt, or a requirement for a trial rather than just throwing people in prison without a trial. That is actually an issue with youth offending. It'd be nice if those fundamentals weren't at risk every time there was, say, a surge in youth offending in a particular jurisdiction.
The next thing I'd like to move on to is something that's particularly current within Victoria and broadly across the whole of Australia, given the context of anti-Semitism and laws trying to fight this and laws trying to regulate conduct by individuals. It's the question of, should we be making criminal laws about everything? And is there a potential to be using other areas of the law to regulate behavior instead of having to make it a criminal offense?
Well, this is an issue that criminal law academics and criminologists always complain about, is that they as a group, but particularly in certain jurisdictions, for example, England, have spent a long time trying to answer the question, when is it appropriate to have criminal law and when are there are better ways to do things without relying on the criminal law? In England, most criminal law academics spend their time working out elaborate theories for where you draw the line. But famously, they eventually concluded, and one of their leading academics, Andrew Athworth, published an article saying, is the criminal law a lost cause? And what they did, they weren't actually talking about the cause of having criminal laws. They meant their own cause of trying to draw the line. And they basically admitted that despite all their theories, no one listens to them. The people who create criminal offences don't sit around consulting criminology theories. What they do is they're reactive to particular events. So until a few years ago, there were no bans on Nazi salutes in Australia. And suddenly every jurisdiction, including the federal jurisdiction, has some sort of ban on Nazi salutes. And that happened because of events and also because of successful lobbying by groups who said we have to do something about an event. In some ways, creating a new criminal offence is the cheapest, easiest thing a government can do. Doesn't involve a lot of costs, doesn't involve a lot of resources. They just pass a law and they say, look, we've done something. So that's why lots of criminal laws get made. I think that's why we have laws against Nazi salutes rather than any profound reason to do it. So I completely agree with, I think, the premise of your question, which is, no, we shouldn't have criminal laws on absolutely everything. There's plenty of things we should deal with in other ways, or not even with legal means at all, just with social appropriate and the like. Me saying that, you saying that is going to land on deaf ears because politicians are going to look and say, we need to do something. This is a fairly easy thing to do. It makes for good press releases. It satisfies lots of people. It doesn't really have obvious costs. Why don't we just do it? So create criminal offences. The worst, typically what happens with a lot of these new criminal offences is they never get used. They never get applied. That's not true of the Nazi salute law, mind you, but there's plenty of criminal laws that get passed with great fanfare and then you never hear about them again. So from politicians' point of view, that's a win. They did something and nothing came of it. That's exactly what they were often after.
So, listening to what you've just said, I can kind of see an issue with the making of these laws. So they're inherently reactive, as you've said. And one of the problems I see with this is, one, if they're reactive, that usually means that you want to pass the laws quickly, so they might not be thoroughly thought through enough,
Yes.
meaning they could have inadvertent consequences. And the second thing is, I think when you're making a law that isn't inherently reactive, you tend to have more of a focus on how it's going to affect society in the future. So my concern with some of these very reactive laws is you've identified a horrible situation and you're quick to say we need to condemn this, such as the example of what happened with Victoria, where that police officer was made fun of as they were dying, and they made forward to move through those laws. But then you see situations in the UK in the long term where they start to use these kinds of laws and they start to apply it in a way that the drafters never thought they would be applied. For example, I'm sure that when Margaret Thatcher's government in the 1980s was passing those laws about online communication and the such, they didn't think it was going to go to the extent that someone sharing what is defined as an offensive meme would be facing arrest or some sort of criminal prosecution. So that's my issue with how the criminal law seems to be developing broadly across the West.
Yeah, I mean, I completely agree with you. That's very much a problem. Those laws that were passed by Thatcher were there to stop people calling up phone numbers and harassing and doing heavy breathing and yelling at people. And yet they have somehow become a means for the police to hassle people themselves over what seem to be not always tasteful, but not necessarily harmful things online. So yeah, that happens. That can also happen here in Australia. We have laws like that, not quite the same as the UK's, but we have a federal law which says you can't say offensive things online. It can be used in exactly the way the UK police have been recently using it. It mostly hasn't been used in that way, but every now and then when some startling thing happens, there's pressure on the police to use it. So, for instance, they use that very law against those two nurses who were trapped by a comedian caught by a comedian saying offensive things or terrible things online. Yeah, it's not just a UK phenomenon, and the same thing could happen in Australia. What's interesting is that the UK seems to have more heavily embraced that kind of policing than Australia has today.
Wonder if there's some way that we could design the criminal law or make some sort of provisions in these legislation to future-proof around this kind of thing. Because I think a lot of the laws that we have are well-intentioned, and we should definitely have some sort of law around that. But the problem is about interpretation and application of the law. So is there a need maybe to give instructions, for example, to police for more explicitly when they should be applying these laws, because they seem quite generally defined currently, and we don't always seem to have agreement about what things like hate speech, when something's offensive, what a community standard actually is, and this ambiguity can create quite a lot of conflict and maybe times when we don't want to have an arrest occurring.
You're speaking about something very dear to my heart. I wrote an entire criminal law textbook which was entirely devoted to the question of how do we interpret offences? Not what offences should be enacted, that's a matter for Parliament, but how should they be read in a way which avoids some of the problems you're talking about? And in fact, I taught my criminal law course for years just based all about that very question. How do you interpret these things? And I am someone who thinks that interpretation can avoid a lot of the problems we're talking about. There used to be a rule that what they called penal provisions, which are criminal law and tax provisions, should be read narrowly, strictly, I think was the specific term. And that was designed to say, look, Parliament, if you want to ban something, you need to be very clear what you're banning. Don't pass vague laws and leave it open to uh, over enthusiastic application down the track. Say specifically what you want to ban. And if you don't say it, we'll read your laws as not covering anything that you didn't specifically mention. That would be a good rule, I think. I'm a big fan of that rule, and there are some variations of that rule which you can refine it a little to make it work. But the bad news is that parliaments in Australia and courts in Australia don't much like that rule. The rule they like is you should try to read laws the way Parliament intended them to work. And that's a very different thing because Parliament's intents are often, we want to stop lots of things. We want to give flexibility to prosecutors. We want to civilise debate in Australia or wherever else. We want to protect people from risks. And when you start reading laws in that way, you actually have the opposite effect. You start reading them broadly because you think we don't want to miss out on this terrible thing just because the law doesn't seem to quite cover it. So a lot of these things end up getting read more broadly. So that's my version of the kind of frustration I mentioned before about the English criminologists who want to have this firm line between what should be criminal and what shouldn't be. My version is we should be taking a strict approach to how we read things. But I'm in the same position as the English. No one listens to that approach anymore because it's been swept aside by everyone's liking of reading statutes in ways that serve broad purposes. And those broad purposes could be far too broad.
Okay, very interesting. I'd like to draw this maybe to a couple of concrete examples that people within Australia have probably heard of so that we can ground it in that. The first example, if you're comfortable talking on it, is about the grossly offensive conduct laws within Victoria, which are now attracting 5 years sentences. So if people haven't heard about this basically arose out of the case of Richard Pusey, who filmed and mocked dying police officers after they had been hit by a car on the side of highway. And then in response to this, they were looking, I believe, to find some way to charge him with an offence. I don't believe there was one that they thought existed that was sufficient enough. So they created the grossly offensive conduct law that criminalises behaviour that violates community standards of acceptable conduct. My question to you is, a law like this, is it going too far? Is it too ambiguous? Is there a need for the law such that these kind of trade-offs might be worth it?
Yeah, that's a really interesting question. I mean, there's a particular phenomenon going on with Richard Pusey, which is anything involved in the death of cops always prompts an extreme reaction. The cops hate it when cops are killed. And so they tend to throw every book they can at someone who is involved in the death of cops. The cops themselves in that case were actually killed by a truck driver. And I've always felt that's where the focus should have been. But Richard Boozy got his own focus and he brought that on himself. There actually was, it's not a new thing to have laws like that, the one you just described, grossly offensive conduct. There was already a common law offence called indecent conduct or something, or gross indecency, that's right, gross indecency, which covered at least a lot of that sort of behaviour. It was often used for people who wandered around naked or did sexual things in public, but it wasn't limited to that. It also covered, just people doing kind of disgusting things like pissing on people in public, that sort of stuff. And the only problem with that law really is that it was part of what's called it's a common law offence, which means you can't read about it in a statute book. You have to dig up old cases to learn about it. So all the Victorian Parliament really did in that case was try to replicate an old common law principle in a way that you can easily find it in a statute book. And they specified a penalty for it rather than relying on old-fashioned penalties for it. So it's not really a new phenomenon. It is a difficult phenomenon. I bristle against the idea of defining criminal laws in such broad ways that really it's just going to be up to a jury or judge of the day to put their thumb up or thumb down on whether something's gross enough to count as contrary to community standards. I don't know how you assess those standards. Sometimes people say that they're appalled by some things, but then when you look at their behaviour, they're not so appalled. They'll look up these things online and happily spread videos around, even though they think that the videos themselves are gross. How do you assess these things? So I tend to bristle against it. I'd like to be more precise, but I think, like you're indicating, there is occasionally a need when you're trying to regulate some things to allow a certain amount of flexibility, because no one was going to pass a law saying don't film dying police officers and laugh at them and then show the video to people. No, it just doesn't occur to people to do such a thing. The actual origins of the community standards language that's used in Victorian law is actually from, it's relatively modern. It's from the attempt to ban what used to be called upskirting. Someone stood under the stands at the Australian Open in the mid-2000s and trying to film women's underwear from underneath a stand. And when they passed a law saying don't do that, they realised it's actually quite tricky because people film their naked toddlers in their house, that's that sort of thing, and no one gets upset about it. So they inserted language about community standards there to try and say, just don't cross the line. And that's really the origins now of that current Victorian law. It just says don't cross certain lines. I can see the need, but obviously I do bristle against that because I don't think you can. A thing I used to do when I taught criminal law, usually law students are tested by saying, here's a thing that's happened, apply the criminal law to this. My criminal law exams always said, here's a person who needs to know what they're allowed to do in the future. Are they allowed to do this thing or not? So for instance, you can imagine an edgy artist who wants to do some really edgy act and wants to know whether they're allowed to do it or not. And I don't know if you could advise them under Victorian law whether they're allowed to do certain edgy acts. I doubt the people who drafted that offence on gross conduct were thinking of a theatrical performance where someone does something extremely edgy, but that doesn't help when you're trying to advise someone on what they're allowed to do. So that's where I push against it. If you can't advise someone, then that seems like a bad law.
I definitely agree on that. And this kind of law, for me, when I saw it first coming out, I definitely had quite a lot of concerns around the ambiguity and just looking at how this ambiguity plays out across the world and the negative consequences of that. But my next question on this, is there a way to design laws like this which avoids this? And maybe one solution I might posit to you is using the jury system more. So if we're talking about community standards, a fair way to determine what the community thinks is, okay, you've got something that generally falls within the framework of what we think is going to be an offence, but we're leaving it more up to the jury to interpret in that situation where they think it has actually violated community standards. Because I think if we're just leaving it up to judges or legislators, that's leaving the system open to their own personal biases, whereas it's not really reflecting what the common Australian thinks on this kind of issue.
Yeah, I think juries are useful that way. I mean, that's really why we have them, is to insert some community standards into the criminal justice system. I think a particular virtue of jurors is it's not just a juror, it's 12 of them. They have to more or less agree. So I'd be comfortable, I guess, in a situation if 12 jurors all agreed something was contrary to community standards, then maybe that's close enough to unanimity across the community that it'd be okay to let them draw that line. I don't know if they're quite directed in that way. Typically, jurors they don't feel like they should be the decision makers. They want to hear from a judge. What should we do? What are the rules we should follow? And so, if the judge, I don't know if judges outright say to the jurors, "I don't have any rules for you. You have to work this out. You just have to all agree." I don't know if that's how they're told how to do these things. There are actually quite a few offences, including, for example, theft, that rely heavily on community standards to define the outer reaches of an offence, or fraud, for instance. So, to give an example, I often give in class, lots of people think that lying is a bad thing, and that lying to get property um, is a crime. That's fraud, right? But every time you haggle with someone, every time you say, "I'm going to pay $50 and not a cent less," and the other person says, "Nope, I won't accept anything less than $100 for this," everyone knows both of those people are lying, and they're going to agree on 75, right? They've both lied to get a financial advantage, but the definition of fraud has a requirement that's called dishonesty, and it's very much like what you've just been describing about community standards. The community has to decide whether that's okay or not, and generally communities are pretty okay with those sorts of lies. They're not okay with others. So it's been part of the system for a long time. So jurors, yeah, can do all that, but the caveat is I'm not sure they're directed to do that. And secondly, and more importantly, jurors play a pretty minimal role in most criminal justice. No one can afford, prosecutors, not defendants, not the government, to run lots of jury trials. So ultimately, most of these cases aren't resolved by jurors. They're resolved in plea bargaining, or they're resolved by magistrates. And I don't have that confidence that the people involved in plea bargaining or magistrates have as good an ear for community values, and specifically the ability to say, actually, I'm not sure there is a community standard on this one. I don't think the community has decided whether a particular thing is bad or not, and to let it go. So they're more likely to say, I don't like it, so I'm going to regard this as within the crime. It just occurs to me, because it's come up in our discussion already, the Nazi salutes, that grossly offensive conduct offence that Victoria passed, that could have been a mechanism to deal with Nazi salutes. All you would have to have done is convince a jury or whoever that there's a community standard that says Nazi salutes are rarely allowed and shouldn't be part of our debate. The problem is it wasn't clear that was the case because for decades people have done Nazi salutes in various contexts, both because they're Nazis or because they think it's a powerful rhetorical device to criticise someone. And I'm not sure the community would have had that firm view that Nazi salutes are abhorrent. So instead, they passed a law saying, actually, we're going to specifically ban Nazi salutes except in certain circumstances. And that was their attempt to not rely on community standards, but drive community standards. They wanted to create a new norm where the community is horrified with every Nazi salute. And so these days, if someone did a Nazi salute in Victoria, I think that would get a very strong reaction because the criminal law bans it in a way that it didn't, say, a decade ago. The complex problem is, what do you do with someone who wants to do a Nazi salute, not because they're a Nazi, but because they want to call Dan Andrews a fascist, or call Anthony Albanese a fascist, or call Howard a fascist, or whatever. Those people are using a Nazi salute ironically. They're accusing someone else of being a fascist. But the new norm in Victoria makes it very hard to make that argument. There is an out for using Nazi salute in opposition to fascism, but it's not at all clear it covers that kind of ironic use. Instead, it's become a taboo. So the Victorian government and others who follow them succeeded in changing community standards. So that's the other role the criminal law can play.
I suppose the out could potentially be making it clearer that intention should be a very clear element within the offence. I imagine why we criminalise something like doing a Nazi salute is we want to root out anti-Semitism. So if your intention wasn't to do those kind of actions, where it was just to criticise Dan Andrews, for example, that would mean that you wouldn't be convicted of the offence, and whether just making that clearer within the law. Because obviously we're going quite far with these laws when balancing up personal liberty versus government intervention to protect things that we think. So maybe we have to make that clear decision here on that issue.
The difficulty there is you end up playing whack-a-mole. The Nazis you might want to stop, or the anti-Semites you might want to stop, will just avoid doing a salute. Or they'll say, I'm doing a salute not because I'm being anti-Semitic, but to protest the law, which is stopping me doing a salute. And how do you deal with them? Those neo-Nazis who stood outside the New South Wales Parliament, none of them did Nazi salutes, and yet everyone got horrified by them, but they weren't caught by that law. While someone else who's some student who does a Nazi salute to protest their vice-chancellor will be caught by law, and it's going to be the out you'll propose is going to be a complex one to define. You could say, okay, they intended to protest the vice-chancellor, not being anti-Semitic, but at the same time, there will be people around them who will treat that salute as anti-Semitic. How do you deal with that? So these are pretty hard ways to define things and hard ways to do things. And of course, it's also not clear that that was the goal of the law. Was the goal to stamp out anti-Semitism? I mean, good luck with that. Or was it its goal to make that particular mode of communication a taboo? I think it's been more successful at that. Uh, These are, interestingly, all these laws were modelled on what Germany enacted in the 50s and 60s. And they will say that their goal, they had multiple goals. One of them was to make these things taboo.
So I guess to pose a difficult question to end this topic is, given all the concerns we've raised today on these areas, on these laws, do you think Australian governments, state and federal, should try and stop passing these kind of laws, whether we should be looking at repealing them because we're thinking they're too dangerous to people's individual liberties, or is it something we just need to live with because the possible side effects of it are worth the positives?
It's absolutely both. I totally think they should do less and they should repeal laws and all sorts of things, because you can make very cogent arguments that none of these laws are achieving their goals. But those arguments will totally fall on deaf ears. There's no way politicians are going to be moved by academic or empirical arguments about effectiveness of criminal law. They will be moved by the kind of political motivations they have, the I want to be seen to be doing something motivation. This is exactly where the English academics landed, is they realised that all their efforts to bring what they see as rationality to this debate, and I'm not saying they always got the right answer, weren't achieving anything. So when I work these days, I'm not usually trying to argue in big ways that criminal law is bad or the particular expansions of criminal law are bad. My approach is to focus in on the details. And I'll say, hey, you've just passed this law. Do you really want it to work in this particular way? Because maybe you need to be clearer about that. That's most of what my work is. I don't always succeed. In fact, I rarely succeed, but that's the only time I've had any leeway into the system, is to get people who hadn't thought of a particular detail to think of that detail and potentially address it in the law they're enacting.
Okay, so next I'd like to move on to a topic area in which you're very knowledgeable upon, and that's the difficulties in proving sexual assault cases, sexual harassment cases, and historic child sex abuse. And I'd like an understanding of what the particular difficulties in these cases are, and whether we should be looking at any reforms such as lowering the evidential burden to try and get more convictions in these kind of cases.
Yeah, I've got a long history of this one, although it's a much, much older topic than anything to do with me, which is I did my PhD thesis trying to work out how to proceed in a situation where crime happens entirely in private and leaves very little in terms of forensic or physical evidence. So, and obviously I had sexual assault in particular in mind, including child sexual abuse, because sex typically happens in private and so does sexual assault. So you have what are called one word against another trials, where the complainant says this is what happened. The defendant says, no, it didn't happen that way. What happened was not a crime, whatever else it might have been. And problem is, how do you reconcile all of that with the criminal law idea, which is that if there's a doubt, you acquit, that you need proof beyond reasonable doubt? There's no solving that problem, to be blunt. You can't create evidence where there is none. And although some sexual crimes leave a trail of some sorts of evidence, digital evidence or the like, or DNA evidence or the like, a lot of them don't. And a lot of the key dispute issues are just a matter. The only truth is known in two people's minds. So, for example, in the George Pell case, until George Pell died, there were just two people in the world who knew the truth of those allegations against George Pell and his accuser. And there was never anything else you could really point to that would cast a lot of light on that crime. Uh, None of that means you can't prove these cases, because everyone accepts, or almost everyone accepts, that it's possible for a juror to look at two people, see them talk, and then decide, we are sure beyond reasonable doubt that that person is correct and that person isn't. Or alternatively decide, no, there's too much doubt, we will acquit because we don't know. It's possible to do, but what is murky is when that's sufficient. When can you be sure enough? And there are a number of things people point to. There's whether the story told by one side makes a lot more sense than the other one, whether that person has said the same thing consistently or has changed their story, whether their actions after or before were consistent with that story. You can point to all of those things. And everyone accepts those things can get you over the line, but everyone disputes when it's enough. All right. So that's a very difficult question. That has led a lot of people to say, hey, we should have a lower standard. My question is always, what lower standard? What's the alternative way you would resolve this fight between two people? Do you just say, actually, I think both of you are correct, so we'll convict. Both of you are plausible. I don't know which of you to believe. We'll convict. No one thinks that's a good system. So what's this alternative standard that people would want to do? That's always my question. I can't think of an alternative to beyond reasonable doubt that I guess I would accept, but I suspect it's also true that most people would accept. I don't know for sure, but I think there'd be a lot of hesitation on a standard that's lower than that.
Wonder if there's other reforms we could be making, because obviously lowering the evidential burden, to me, I can see merit in it, but I can also see that as being extremely dangerous in balancing the fairness of the legal system, accuracy of convictions versus actually getting the convictions. So I wonder if things like potentially giving police greater powers to monitor individuals who have been accused of these crimes, to give them greater powers to gather the evidence, whether that's a potential solution, noting that this is inherently a crime in which gathering evidence is harder than almost any other crime. So potentially we need to create greater police powers to
Like
investigate.
what? I mean, the police have lots of powers to gather evidence. They have search warrants. They can bug people's phones. I mean, a favour of the police when they're dealing with historical allegations, especially child sexual abuse ones, is they get the complainant to ring up the accused and say, let's just have a talk about what happened. I'm traumatized by it. I want to know where you stand on it. The goal of that complaint is to get the accused to apologize and to do it on tape, which means you can then use that as evidence against them in court. It's pretty controversial, but it's often used by the police. So they have powers to do these things. I'm not sure what other powers you would want. I don't know what you're proposing as extra powers. Police are pretty powerful. The limit isn't the police's powers. The limit is, what are they going to do? I mean, that method doesn't always work, or it yields ambiguous results, or it's fluffed by the complainant in some way. I mean, they're not trained to be interrogators on the phone. What extra powers would you want the police to have?
So I guess from what you're saying is that the police already have quite significant powers. It's a situation in which we have to almost accept that there isn't much of a fix here. These are crimes which are uniquely very difficult to prove with our current technology, and we're going to just have to accept that it's difficult proving these cases. But perhaps what's the better solution here is to think about things like prevention, about better early detection, instead of looking more on the conviction side of this issue.
I mean, you should be doing all these things. But again, how do you prevent? How do you detect? Um, I mean, we're having a debate right now about the childcare system and more broadly working with children. We have laws that try and regulate who can work with children. And the current proposals everywhere, in light of incidents in recent years, is it should be easier for the government to say no to some people who want to work with children. They shouldn't have to wait till that person is charged or convicted. They should rely on lesser evidence. And what they always mean by that is reports. someone has reported something about that person. So that's the change. But what it does mean is one of the assumptions that is usually behind these kind of allegations that you're going to get your day in court, that you'll get tried, that a jury will decide or a judge will decide doesn't apply in this situation. Instead, there'll be a report. I guess it's not clear how. Someone will look at that report and decide whether it stands up or not, but they're not going to be doing it in a trial. They're not going to be asking you to weigh in or the accused to weigh in. They're just going to be making decisions. And in decisions about a major part of life, a major part of employment, a lot of people, that one of their major job options is some sort of working with children in some way. Weirdly, as an academic at Melbourne University, and I teach a law degree, which is only available to graduate students. All my students are 22 or 23 or over. They're not children. But I have to get a working with children check because the university as a whole has students some of whom are 17. So I guess I, like anyone else, would be vulnerable if someone made an accusation against me. I could be barred from my current job that I've had for 20 years without a trial. That's not to say that's a bad system, because the other side, if you don't do that, you expose genuinely vulnerable people to genuine predators. But it is a real compromise that there's a cost to take to trying to stop those predators. Whether you even succeed in stopping those predators is another matter, but there's a cost regardless when you do so. So yeah, you should be trying to prevent, but again, that's no easier than trying to prove. All these things are incredibly difficult things to do. I mean, I should address the current, for decades, the standard everyone has tried to make is a change to attitudes about who people believe. So, I mean, the whole terminology used to be that there were all these rape myths, that rapes only happen in particular ways, and if someone doesn't fit the picture, you don't believe them. Or that false reports are really common, and so you should be skeptical about any report because reports are common. The pushback was to try and change those attitudes. And to some extent, that pushback has succeeded. Jurors these days are much more likely to convict than they were in the past. Difficult question whether they have got it right, whether those things that were regarded as myths are necessarily myths, whether the current belief systems are correct or not. Those are really hard questions. But that has probably been the major change in recent decades. So allegations, like the Pell allegation, for instance, that would never have got into the courts decades ago because everyone would have said no jury is going to find proof beyond reasonable doubt in these circumstances, did get into the courts, did get a conviction, albeit one that did not stand up on appeal.
The interesting thing I've noticed here in our discussion so far is the amount of both ambiguity and the imperfectness of the criminal law system, that it seems no matter how you design your criminal laws, there's always going to be costs. There's always going to be someone in some situation who gets the bad end of the stick on it. And I guess that's something we just have to accept and constantly be weighing up trade-offs about how the benefits of the system versus the costs, and that's maybe something we have to accept as being inevitable in these
Well,
kind
you're
of
probably just
systems.
getting a real taste of how I teach. I'm not sure it's always popular with my students, but just about every bit of the law I teach, I find ultimately I'm a bit of a pessimist on whether this bit of the law is going to work all that well. It's not that I think that, say, evidence law, which has its own problems, or criminal law should be abolished, but I'm not someone who's here to say the law gets it right most of the time or is mostly doing a good job or there are mostly easy answers to these things. I actually think there's plenty hard. It's all a lot harder than most people assume, and it's all a lot more fraught. So often I'll be posing the question, what should we do about this problem? But I'll tell my students in advance, I'm going to shoot down every answer everyone gives because everyone's thought about this for a long time and no one's come up with good answers to these things. I mean, sometimes I'm surprised, to be clear, but you're mostly catching my take on how to teach law. It's not just about criminal law, or it's also about other parts of the law as well. I'm pretty pessimistic about finding easy answers or even effective answers most of the time.
So the last thing I'd like to touch on today is about domestic violence. This is not a unique problem to Australia, but the statistics on this are startling. Using the 2021 to 2022 figures, 27%, or around 1 in 4 women over the age of 15, have experienced domestic violence in Australia. I'll ask you if you have any thoughts of some kind of policy responses or procedural fixes you think could be effective within these kind of cases. But first, I want to posit a proposed response put forward by a criminology professor called Vincent Hurley, and I'd like to hear your thoughts on it. His proposal was that males with history of crimes of violence, of any form of domestic violence, should not have the presumption of bail. This policy would allow the offender to be taken off the street and allow women time to get to a women's refuge or provide them with time to create proper precautions. I could see this kind of policy greatly increasing women's safety. My question is, does the removal of the presumption of bail here breach legal principles within Australia? And would it be successful?
Yeah, I mean, there's a lot buried in that policy proposal. If the goal is to give women time to find safety, then the issue isn't the presumption of bail. The issue is dealing with someone in the immediate aftermath of a complaint. So you want to give days and weeks to give someone clear time. And you could have a preventative detention scheme where someone can be detained for a while to allow someone who's alleged domestic violence to find their place and find a place of safety. That's a different thing to getting rid of the presumption of bail. So bail is, if you get rid of the presumption of bail, it's all about detaining people without a trial and detaining them until they are tried. Effectively, what you're saying is you'll detain people if someone complains, or if a cop believes that complaint, or in some situations, if a prosecutor thinks it's worth resolving whether that complaint is true under the criminal law. That's giving an awful lot of power to all those people, to someone making a complaint, to a cop and to a prosecutor, to detain someone without a trial. I balk at that. In general, I think the only reason you should be detaining people without a trial is because if you don't, they will get away and you won't ever get to try them at all. If you need to do something with that person while awaiting trial, the answer should be rules designed to regulate safety in the meantime. And I don't think locking someone in prison is necessarily a good or certainly the only way to regulate safety in the meantime. The other catch in that proposal I noticed you mentioned is that it should be limited to men. And we all know it's the well-known part of criminal law, so well known that it's rarely even voiced, that men are the main problem when it comes to crime. The men are overwhelmingly the criminals, and men are overwhelmingly the sources of things like violence. But a problem that's happened with just about every domestic violence reform in Australia is no one's willing to pass a law just for men. So no one's in the recent childcare issue, which isn't domestic violence, but it's related. Everyone's worried about the male childcare providers. No one's willing to pass a law saying ban men from childcare. And in domestic violence, no one's willing to pass a law saying a bespoke law for men for domestic violence. Instead, they pass general laws. So they pass things that say to the police, the police in the past would take a hands-off approach to domestic violence. It's not our place. A household can deal with this. We'll keep out of it. This is a decades ago approach, but it's a well-known approach. And so laws were changed and policies were changed to tell the police, stop doing that. Take a hands-on approach. You need to provide written reasons if you don't arrest someone. You should arrest someone. You should prosecute them. And what actually happens in a lot of those cases is that women got arrested and prosecuted because the police would confront two people with injuries, or they would confront a man with injuries, with visible injuries, and they go and arrest the woman. And that wasn't the intent of the proposal. It was meant to be controlling men, but because no one was willing to say we are only going to control men, the police were left in a position where ordinarily they would be hands off, but instead they intervene and they have to pick who's the right side in a fight. And it's not always men who they pick. The difficulty with all these proposals to tighten and make domestic violence laws tougher is they can have a lot of unintended effects. And that comes down to where I started with this. If you are putting all the power in the hands of a complainant, that could be a complainant who's ill-motivated. A man, for instance, but not always the men either. If you put all the power in the hands of a cop, that could be a cop who just makes poor judgments, who has their own biases, who comes in and gets the wrong side of an argument and doesn't quite see, has missed context. Or it could be a prosecutor who just has a particular approach and a particular set of lines which don't always get the right result. And once you start doing that, applying massive consequences to those decision makers means that you have a lot of people who get caught up in a system when they shouldn't be. So it could be protective, but it's very difficult. There's a recent research that has tried to pick up the argument that one way there's a concern about the number of women who are murdered by their domestic partners. Complex issue because unlike the other stat you gave, which is about general experience of domestic violence, there's generally good news about domestic homicides. They have got much less common over the last 3 decades than they were, say, in 1990. We're going in the right direction, even if we haven't got to where we want to be on domestic homicides. But what he was interested in is the repeated claim in the last few years that if there are red flags that are a good guide to whether someone's likely to commit a domestic homicide or not. So he went back and looked at a whole lot of people who had been flagged early on as potential perpetrators of domestic violence to see which ones became the murderers. And the problem is none of the red flag approaches worked. None of the red flags were reliable indicators that someone would be a murderer, basically because murder is so rare that the red flags overdetermine everything, right? The various things they look for. Yes, quite a few of the murderers will have those red flags, but so will 1,000 times more other people who also have those same red flags. So the benefit you get from locking up people with red flags is you may well stop some of the murders, but you will at the same time lock up thousands upon thousands of people who would never go on to murder. And there are massive costs with doing that. There are all sorts of disruptions that you cause by doing that. So yeah, this is another area where I'm pessimistic. There has been a change of attitudes. There has been a heavy use of at least what start off as non-criminal law approaches in domestic violence. So the order system, the apprehended violence order system, where people are given directions, don't go near that house and so on. That was designed to be an alternative to locking people up. It's not wholly successful. People don't always obey those orders, and people also who are subject to those orders fall into their own traps. But again, I'm a pessimist on whether these other approaches would work. Certainly on the idea of overturning the presumption of bail, a constant debate. It's a debate with youth offenders as well. It's important to bear in mind that what you are saying is someone can be locked up if a police officer wants them to be locked up, sometimes for months, sometimes for years. That's a pretty tough call to make. A lot of power to give a police officer. Even a well-intentioned police officer is going to get that wrong. So it's again, I balk at that. This is another area where nothing I say will make any difference because bail is a hot button topic. Politicians like to toughen bail when there's a crisis. It's just been happening recently here in Victoria. Unlike some of the other political responses, creating new offences and the like, tightening bail comes with a massive cost to government down the track because it's really expensive to keep people on remand. When you have large numbers on remand, you have to spend a lot of money. So in the end, governments ultimately can't sustain an approach like that. It costs too much. Victoria is an interesting jurisdiction that way. It has one of the lowest imprisonment rates in Australia, but it used to be much, much lower. And in the last couple of decades, it doubled its imprisonment rate, which is an astonishing thing for it to do. I think it's a real pity. I don't think prison mostly does a lot of good. I think it's mostly a bad thing. That being said, I'm not a prison abolitionist. We need prisons, but I would want to minimise the number of people we have in prison. I wouldn't want a situation where we double the number of people we have in prison, but Victoria has done that. It's not at all clear that has helped the crime rate or the other social problems here in Victoria. What it has really done is hurt the government's budgetary position. They're struggling to afford that system. So I think there's a lot of, unlike some of the other more theoretical criminal law issues we've been talking about, this one really does sound in specific outcomes for people. And I don't think they're all one way.
So, one response I might have to your qualms with the presumption of bail is whether a way to deal with the harms you're bringing up about indefinite detention is maybe you create a framework where, okay, we're willing to accept that there's situations, maybe certain classes of crimes where they're so severe and the risk to the victims of a repeated offense from these perpetrators is so severe that we might want to remove the presumption of bail. And to kind of balance the concerns you might have, it could look like having a framework to increase the court date, so making sure they get a court appearance within a month, potentially looking at creating special courts to deal specifically with these crimes. A crime like murder, a crime like sexual assault, domestic violence, it might be more important to try these crimes first versus a financial crime or something like that, given the safety risks it poses to society.
No one thinks financial criminals are a safety risk at all. So this whole discussion is really about violent crime. I mean, a lot of these difficult questions about what to do awaiting trial would be much easier if trials happen quickly. I'm always amazed when I look back at, I like looking at old cases from 100 years ago, and a murder happens one week, someone's arrested the following week, they're tried the following week, they're executed the following week. It's all very quick and speedily done, and no one had to have a big dilemma about bail. But it is not the world we live in now. It would be a nice thing to have quick trials, but ultimately neither prosecutors nor defendants are willing to have quick trials. They want to take their time, investigate, slowly resolve a large set of issues that have to be resolved before you have a trial, prepare for trials. None of that can happen quickly, and there's a massive resources problem when you're trying to have quick trials. Where do you hold them? Who runs them? Where do you find these jurors? Those are like logistical problems that make it almost impossible to do anything quickly these days. That's not specific to criminal law. It's true of everything. It also takes a long time to build a new, train line or whatever than it used to be in the past. All for the same reasons. There's too many hoops you have to jump over. So it would be great to have quick trials, but I don't think that's going to happen. Otherwise, the system you've just described, where you have certain crimes where there is no presumption of bail, that is our current system. The statute, every bail act in Australia has a schedule at the end that says, here's the list of crimes where you don't have the presumption of bail, you have a presumption against bail. Victoria has it, others have it. They're always fiddling with what's in and out of that list. So we already have that system, although none of them are mandatory. Not having the presumption of bail still means you can get bail. You just have to convince a court to give you bail rather than the prosecutor convincing a court to refuse bail. That's all that happens. And even in systems where the government announces, we are definitely going to lock up every person accused of carjacking, for instance, actually about a third of those people still don't get locked up because they always have something special, which means in particular, it would be a bad thing to lock them up for a year awaiting trial. So the system you've described is the system we've got, but the ultimate problem is, how do you pay for, run, logistically manage a speedier system? Or alternatively, how do you handle all the edge cases which are inappropriate for your tough rules? And that's a constant problem, and every jurisdiction struggles with that problem.
What I find interesting on the issue that you've raised about costs and length of trials is thinking about, well, how much money would it actually take to give the legal system more resources to facilitate an increase of time? Because if we look at things like, say, the growth of NDIS spending federally, we're talking billions of dollars, and the government isn't going, we can't fund this spending increase. And if we look at the costs to human life, to people's ability to engage in rehabilitation, for victims to feel safe, the criminal law system is equally important, I would argue, as NDIS. This is something that tangibly affects people's lives. So do we have to start having a discussion and start having some sort of activism or motivation to our MPs talking about, well, we should be funding our criminal law system more. We should be looking at actually reforming the regulatory hoops people have to jump through to conduct these trials, because honestly, we're having individuals who are getting seriously harmed by how the status quo is acting. And it's all well and good for politicians to continually talk about how big of an issue things like domestic violence, youth offences are, but if they're unwilling to fund the system more, reform the regulatory system, we're not going to get any actual change.
I mean, I haven't done the figures, but I'm sure you're right that the money spent on things like Social Security and in the IS and all of that absolutely dwarfs the money that's spent on the justice system. It's barely comparable. So you could imagine, without massive impact on the bottom line of any government, spending 5 times as much on criminal justice, having 5 times as many judges, building a whole lot of courthouses, training and paying a whole lot more lawyers to run through the system and so on, having lots more prisons. You could imagine it without a budgetary effect, but I think it's going to be a little bit like the problems that befell the NDIS. It's not clear you'll get the bang for the buck you need from all of that, because once you pour money into a system, the system just adjusts around it, right? So all those judges will now not necessarily run trials quicker. They'll still say, well, now those the previous corners we used to cut to make this system work, let's not cut them as much. A crucial corner cutting mechanism, the plea bargaining system where people plead guilty because they don't want to have to wait for years and make a difficult argument, an expensive argument at trial. If there's plenty more judges, people might stop pleading guilty and might go to trial more often, in which case, instead of getting the kind of protection you want, which is a more robust system that can quickly clear up problems, you'll just have a more cumbersome system, which, if anything, more slowly deals with problems. So again, this is just me doing my standard thing. You've suggested a solution, but I actually suspect that massive amount of extra funding would not necessarily result in the kind of outcomes you want. It will just, in the same way as you build a freeway to clear up traffic and then everyone drives more and the freeway gets clogged up. I think a similar phenomenon will be in place with criminal justice. Pouring money into the system won't necessarily solve this problem, unfortunately. Again, it's a bit like proof in sexual assault trials. I'm not sure this is a solvable problem. I don't think we have an ability to make society safer, which is anything other than cumbersome and ineffective.
Well, the only counter I would have to this is we could approach this also looking at the attitudes of the judges, of the lawyers involved in the legal system, and trying to change those attitudes. A judge, when they're sitting on a case, I would imagine it's a great responsibility, and they're probably thinking, I need to do this to all the greatest standards, take these lengths, but maybe starting to institute the idea in the judges' heads, things like, well, if I'm taking too long on this one particular case, I need to think about the other people who are waiting in line to have their cases heard and all the detrimental impacts on them, and trying to change attitudes that way to have a more comprehensive awareness of the whole legal apparatus.
It's, again, very challenging. I mean, there are judges out there who set out, I'm going to cut the corners, I'm going to be quicker, I'll do all this. They tend to become vulnerable to appeal because the unhappy party who thinks, I just lost very quickly to someone, I better appeal this because something seems wrong about the speed. Then they get an appeal judge who says, yeah, on this occasion that was too fast. You should have taken your time. It becomes a false economy for those judges. They hurry, and that just pushes the problem further down the track. I mean, if you could get all of them in lockstep, being happy with a quick process, you'd be fine, but that would be difficult. I mean, there was a simple push in Victoria a few years ago to save money, but ultimately to resolve some of the problems you're talking about, by the government no longer funding 2 barristers on the defence side for every murder trial. I said, one will do. I mean, why do you need 2, right? And in fact, several states in Australia only fund 1 barrister for murder trials, not 2. So we'll just do what they did. But the Victorian courts pushed back against that and said, no, if you're not going to fund 2 barristers, we'll stay the prosecution, because we don't believe that you can have a fair murder hearing without 2 judges. How are you going to deal with that? Are you going to pass a law telling every court in Australia you're no longer allowed to stop prosecutions? We kind of need those judges having that ability. But at the same time, I personally think those judges got that call wrong, but that doesn't help us.
Okay, well, this has all been very interesting. I think it's, if nothing, it's highlighted the difficulty of making any meaningful law reform, and how everything seems to be a bit of a double-edged sword, which I guess it gives me a little bit more empathy for politicians with what they're struggling with, and with judges when they're drafting these laws, because it's quite complex. You can easily make quite a muck-up of all of it. It's been a pleasure, and I hope the audience has learnt a lot, and it's hopefully widened their perspective on these kind of issues today. Thank you for joining me, Jeremy.